Do tell.
So let's start with some atmospherics,
Please.
Which is the hearing was supposed to start at 2 o'clock, and at 2 o'clock, Judge Dearie comes out on the bench, like clockwork.
Oh, wow.
And that is Judge Dearie. There's a real tradition in the Eastern District that they are responsible, they adhere to rules and order. It was a prompt, efficient hearing. It ended at 2:40. With Dearie having given everyone an opportunity to be heard, but he also conducted it. It was like an adult in the room, and everyone had to behave themselves. So that was sort of the atmospherics, and there were, with one exception, which I'm sure we'll talk about, there were no histrionics on the part of either side. And in terms of the merits, the key is, it really was put up or shut up, but it was said with a lot of judicial, in a Judge Dearie way, exactly. And he, at the outset, made it clear. He said, "You may have Trump team, you may have litigation reasons and strategy as to why you don't want to tell me or the world in a court of law that these documents are classified. That's fine, but if you don't do that, I have in front of me a prima facie case, meaning that the government has set forth sufficient evidence that these are classified. For God's sake, they bear markings that say they're classified." So he said, if you don't want to actually say anything at this point, that's fine, but I'm going to rule. And that was really the theme of the hearing, because at some point when they started talking about whether there would be a need for people to actually have clearance to see not just top secret documents, but top secret compartmented documents, right. Judge Dearie said, I may be able to decide this issue where I don't even need to see them. That we don't have to get into that issue. No, he didn't say that's what he's definitely going to rule. He wants to hear from the parties, et cetera. But it seems pretty clear in terms of his thinking that he's going down the road of, if these are classified documents and I have no contrary evidence, then that sort of leads to a conclusion, which is I'm not returning these documents to you. So if you don't put up, then you're not going to get the relief that you're seeking, which is to have the documents returned to you.
It also sounds like from what you're describing is even if you do put up, then the process begins. Because it sounds like the person that Trump picked, and there's some neat reporting in Axios about why he thought he would go his way. It's sick and twisted and very Trumpian. But he's a FISA judge. He knows exactly what we're talking about. Talk about what the sort of difference, you talked about the atmosphere, but what's the difference in terms of the legal arguments being made in front of a judge like Judge Dearie as opposed to Eileen Cannon?
Well, here's an example that goes to exactly what you're saying. He said, let's assume that these documents are presumptively classified. He wasn't going to go ahead and make a ruling. He said it is the obligation of the government to make sure that these are not shown to people needlessly. That is their obligation. That is a completely different mindset than, when they were in Florida. And, my sort of euphemism of this is like you're not in Florida anymore. You're now
happens in Florida, stays in Florida. Exactly. I want to ask you about the exception. What was the exception when there were histrionics?
Yeah. So at some point there was a discussion about whether the judge would consult with the National Archives, NARA. And the government had submitted in its letter sort of a one-line saying, we really encourage you to do so. Not a lot of meat on the bones about why. Jim Trusty, frankly, the only lawyer who spoke for the former president, who, by the way, he kept on describing as the president and saying he's the president's lawyer, that's the one time I was waiting to see what Judge Dearie would do, because he went on a political attack of the archives. He talked about them being a political entity. The archives.
The National Archives.
That's like saying it's a political entity. Like my public library is a political entity. He seemed to equate what Sandy Berger did to being the archive's fault, that they wanted those documents to be taken. And so the argument was that the judge should not be consulting with such an overt political body as the National Archives. Judge Dearie basically said, I don't actually see the need right now to consult with them, so this is a moot conversation. But in his very polite way, he said, of course, I do think, you might be painting with a broad brush there.
Oh, wow.
Which was his way. I mean, Judge Dearie is no fool. He knows exactly what's going on. He called them out in an adult way. But that's the one place where I thought that Jim Trusty was not reading the room and decided he was going to go on a planned diatribe that clearly was coming from his client.
Tell me what each side, for the DOJ side, one, who was there? Is it a name that we recognize from the filings that we've seen? And what did they argue, and what did they want out of this hearing? And then do the same for me for the other side.
Yeah, great question. So there were 5 lawyers from the government. One of the lawyers was from the taint team, which was necessary because the judge needed to hear what the taint team was doing.
Explain that. It's the filter team? Is that the same thing?
Exactly. This is the filter team that had culled out things that were potentially attorney-client privilege. And so there was a report from that lawyer saying that, I separately have pulled out that information. We have given it to the Trump team already. We're creating an inventory of that. They handed the inventory actually up to the judge right in court. So the judge was very pleased. He said it's great to see progress being made. As the judge said, he wants to act with responsible dispatch. And maybe one backdrop to this is that what we learned today is that it was Judge Dearie who had proposed a 4-week schedule, not to the end of November, but 4 weeks.
Oh, wow.
That was faster, just to be clear, that was faster than what the government had proposed, because the government's letter had talked about coming back in a few weeks with progress reports. And it's pretty clear Judge Dearie does not see this as complicated, that this is just not that big a deal. So anyway, going back to your point, the government wanted to report on the progress of the taint team, the so-called attorney-client information. And there was very little that the government otherwise had to do other than sort of report about having a vendor, certain mechanical things. The main person speaking was Julie Edelstein. I actually don't think any of the other lawyers really spoke of any substance. She was asked by the court about what happens if the 11th Circuit doesn't grant a stay. And interestingly, she said, we will have to get back to you because I'm confident we'll be looking at other appellate options.
Wow.
Which means the Supreme Court.
So DOJ is preparing to appeal to the United States Supreme Court if they fail in the 11th Circuit?
Well, she didn't quite come out and say that, but it was hard not to
deduce.
Yes,
Yeah.
it was
Wow.
clear what she was saying is this is so important to the department that I'm not sure we'll leave it there. Obviously, they would have to see the decision and make an evaluation, but I thought that was notable. And it was basically telling Judge Dearie, don't count on this being, if the 11th Circuit rules against us, don't count on this being over so quickly. So that was basically it from the government side. Jim Trusty did all of the talking for the Trump team. And, he had a tough sell here. He was doing something that is very typical of lawyers in a criminal case, and that is delay. It's famously been said by Edward Bennett Williams that in a criminal case for a defense lawyer, an adjournment is an acquittal. And so, this is not new to Judge Dearie, which is Jim Trusty kept on saying everything's premature, we need more time, it's going to take a lot of time. Everything that was being proposed, he kept on saying why things were going to take longer. It's very clear Judge Dearie is not going to have any of that. Judge Dearie made it clear after he heard from both of the parties about his proposed schedule, that is the court's proposed schedule, he is going to issue an order. And that's, Judge Dearie is no pushover. He is going to have an order. He's going to expect everyone to adhere to it and make rulings. So I think that's what the court was trying to get out of this.
And just one more question, just to make sure I understand the process and what was on the line today for the government. If his ruling is to sort of express satisfaction with the work of the filter team or the taint team, does the investigation, the criminal investigation, and the national security damage assessment proceed in that 4-week schedule? I mean, is the best case scenario those 4 weeks or how long we wait until the criminal investigation into Trump and the national security assessment can proceed?
I think there is a potential for it being even faster. I would say if Judge Dearie adheres to the 4 weeks, I'd say that's the worst case scenario.
Oh, wow.
That he is contemplating that from his perspective, it will be done. Now, it is important to remember that whoever is the losing side, and potentially they're losing, each side could have something they want to gripe about, they get to go back to Florida, and Judge Cannon gets to, consider those issues. I have to say, I've always thought with Judge Cannon subcontracting this to a senior respected Article III judge, I think it would put a lot of pressure on her if she was thinking of reversing his rulings, because he's a kind of judge that no matter which way he rules, we're going to be thinking there's a lot of merit to it.